So we have an important update in a critical rifle and magazine ban challenge. The Trump administration recently stepped up and joined the fight against the state of Illinois' ban on rifles and magazines. They argued that it's unconstitutional, and now the state of Illinois is trying to respond, but they're trying to also stall this challenge. So let's break down what is happening. Now, before we jump into this video, if you want to support the channel for free, please consider subscribing to the channel. Also, click the like button. By no means do you have to, but that, of course, helps the channel to grow and reach more people. And then just drop a positive comment down below because that tells the algorithm that you appreciate this type of two-way content and it should share it to more people. Now, as I mentioned in the intro, in this video, we have some great news coming out of a critical case, which is a challenge against the state of Illinois' ban on so-called assault weapons and their magazine restrictions as well. Recently, we talked about how the Trump administration stepped up and filed an amicus brief in this case, and they argue that this state rifle and magazine ban is in fact a violation of the Second Amendment. Currently, the state of Illinois has appealed these cases up to the 7th Circuit once again, and they're arguing that Judge McGlynn's prior decision, the lower court decision, which was pro 2A, striking down PICA, that should be reversed by the 7th Circuit. However, like I mentioned, the Trump administration jumped in support of this case, arguing that Judge McGlynn's decision should actually stand and that the 7th Circuit should find that this rifle and magazine ban is unconstitutional. In response to this, the state of Illinois is asking to push their reply brief out for another month, so they want additional 30 days to fully address all the arguments that were raised, not just by the plaintiffs here in this case, but also the United States government, the Trump administration, and all the other amicus briefs that were raised in support of this case. Now, you may remember originally in this case, there were actually multiple challenges that went to district courts, and those district courts issued preliminary injunctions temporarily halting the enforcement of PICA. However, the state of Illinois then appealed those preliminary injunctions to the 7th Circuit, who later upheld those bans, and that led, at that time, multiple cases to seek immediate Supreme Court emergency intervention. However, the Supreme Court denied emergency review to a lot of those Illinois cases. There was a statement in the denial that was issued by Justice Thomas, so he made a statement, and that indicated that if the 7th Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches a final judgment. The court must not permit the 7th Circuit to relegate the Second Amendment to a second-class right. So although the Supreme Court denied review to those cases on an emergency basis, you did get the statement from Justice Thomas, and he sent a warning to the 7th Circuit. Now, while all of that was happening, while the emergency petitions were going to the Supreme Court, the lower court judge, Judge McGlynn, decided to move some of these cases along to a final merits decision. On review of the merits, Judge McGlynn once again found that PICA is unconstitutional and must be struck down entirely. After that ruling, Illinois then appealed once again to the 7th Circuit, and they wanted the 7th Circuit to reverse what Judge McGlynn said once again. Once again, in the case, they argued that AR-15s and magazines and a lot of these attachments are militaristic weapons, that they are useful in military service and therefore not protected by the Second Amendment. Again, pretty typical arguments from Illinois. We've seen similar arguments from other states trying to protect these types of bans, and now they've appealed up to the horrible 7th Circuit, who again has already ruled at the interlocutory preliminary injunction stage of this challenge. However, things just got really interesting because the Trump administration, the DOJ, decided to step in this challenge and argue that PICA is unconstitutional. The Trump administration recently filed an amicus brief, and in it, the government argues that 3 years ago, the Supreme Court issued a landmark decision meant to break a habit developed by some states of treating the Second Amendment as a second-class right, subject to an entirely different body of rules than other constitutional rights. Regrettably, not every state got the message. Just a few months after Bruin, Illinois outlawed some of the most commonly used rifles and magazines in America via a so-called assault weapons ban. In doing so, Illinois violated the Supreme Court's clear directive that states cannot prohibit arms that are in common use by law-abiding citizens for lawful purposes. In an earlier appeal reviewing a preliminary injunction against PICA, the court held that the act was likely constitutional and reversed, but this court made crystal clear that its opinion was just a preliminary look at the subject. They go on to say that now, after final judgment, there are 3 very good reasons why this court should reverse course and affirm the district court's injunction. First, as explained below, key aspects of the Bevis analysis are wrong, even judged against the Supreme Court's Second Amendment case law that existed at the time. Second, multiple Supreme Court justices have since made it clear that they disagree with Bevis and other recent lower court opinions, and that the court is likely to grant cert in the next term or two to address the errors of these opinions. Third, after the court's decision in Beavis, the district court held a multi-day bench trial, heard significant evidence regarding the issue in this case, and made factual findings that show that the act violates the Second Amendment as applied to semi-automatic firearms and attachments that are in common use by law-abiding citizens for lawful reasons. For all of these reasons, this court should reverse course and affirm the district court's injunction. Again, really great arguments coming from the federal government and the Trump administration against this ban in the state of Illinois. Now, when arguing further in the brief, they state that in this case, the key question under the Second Amendment's text is whether the banned semi-automatic firearms are arms. Many of them, including AR-15s, are arms. So there you have the federal government acknowledging that the AR-15 and similar rifles and semi-automatic firearms are protected arms under the Second Amendment. They even point out that the Supreme Court recently had issued decisions in the Smith & Wesson PLCAA case and other cases where you had Kagan, Thomas, and other justices acknowledged expressly that AR-15s are in common use for lawful purposes. They also point out that AR-15s are not uniquely dangerous and really should be treated the same as anything else like semi-automatic handguns that are in common use for lawful purposes that are recognized as arms. These types of rifles should be treated the same way. They also point out that the militaristic weapon test used by the Seventh Circuit is improper and does not align with what the Supreme Court has said in Bruin and some of these other cases. They point out that the text of the Second Amendment does not support that type of analysis, nor does the history or tradition of our nation. In fact, they point out that the history and tradition of the Second Amendment makes it clear that people were actually expected to provide their own firearms for service in the militia, and those type of firearms that they provided for themselves were used for things like self-defense, but also potentially military use. And so even saying that militaristic weapons are not protected goes directly against the purpose of the Second Amendment. Now, when it comes to magazines, they argue that PICA violates the Second Amendment, of course, also when it comes to magazines. They state that as this court has recognized in the past, Second Amendment protections extend to certain important corollaries of the core right to possess arms for self-defense and other lawful reasons. The Trump administration argues that although these activities may not literally involve keeping of arms, each is a fundamental component of the right protected by the Second Amendment. Applying that principle to the act, the Second Amendment protects firearms attachments that are useful for exercise of the right, including magazines, suppressors, and other attachments that are in common use. And so that is what the federal government here is arguing. The Trump administration says that these types of accessories, magazines, suppressors, and other items are protected arms. Now, there are a lot more arguments made in the government's brief, but that gives you a good idea of the strong two-way stance that the Trump administration is making against this state rifle ban and magazine ban. However, right now, the state of Illinois has responded by asking for another 30 days to file their reply brief. And they're saying that they need more time to address all the issues raised by the plaintiffs in all these new briefs filed by the Trump administration and all the other, amicus briefs that were submitted in this challenge. Recently, the state of Illinois requested that 30-day stay, and in that order, they say, in the order to completely draft the reply brief in this case, I must address 4 merits briefs and 4 amicus briefs, together totaling over 200 pages in length, which exceeds the length of response briefs in typical cases. So they're trying to say we need even more time to file our reply. There's just so many things that were raised. The Trump administration stepped in, and so we need more time to kind of combat the onslaught of arguments that were made against the state ban. So again, another stall tactic from the state of Illinois, but they do have to address all of these things that were raised, and they're going to have to try to combat what the Trump administration just said against PICA. Now, regardless, I will note that the Seventh Circuit now has controlled this case, and if you're going to ask my opinion, I think they're probably going to rule the same way that they did on the preliminary injunction. The Seventh Circuit's track record has not really been good when it comes to the Second Amendment, and I don't think that they're going to take the Supreme Court's warning when it comes to this issue of rifle and magazine bans. However, I will note that Kavanaugh said, it's going to be time soon, maybe in the next term or in a couple terms, to address these types of bans. So if the Seventh Circuit continues to play games, if they don't take those warnings, this could be one of those cases that the Supreme Court is eyeing. They mentioned this one expressly also in the recent denial of the Snope and Ocean State Tactical case. So they are keeping an eye on these Illinois cases, and this could be the one that eventually makes its way to the Supreme Court. And it would be a huge mistake from the Seventh Circuit to continue to defy what the Supreme Court has said in all of their warnings and what they've outlined in Bruin, Rahimi, and all the recent decisions. So that's what's currently going on in the Illinois PICA challenge. The state of Illinois is trying to stall because they have to address all those arguments that were just made by the Trump administration. So as we get more information, as this develops, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.